Charitable giving, the battle between private charity and government charity. The Obama Jobs Bill creates a new battle between the charity world and government. This is David Parker with the Law Office of David Parker and another video blog. There's a lot of commotion surrounding President Obama's Jobs Bill, and for good reason, but not all of it's positive. Small businesses, for one, are lukewarm, since their concern is less for tax breaks and more for actual revenues. But the biggest detractors so far may be just the charities and those that give to them. The bill proposes eliminating some of the deductions for charitable giving amongst high earners. This can have an effect on every New York asset protection plan. The Jobs Bill comes out to a $447 billion price tag, and much of it would be paid for by limiting the tax deductions for charitable giving among top earners making more than $200,000 a year. Currently, these earners can deduct 35 cents on the dollar, but if the bill passes as written, that rate would drop to 28 cents. In fairness, this simply equalizes things so that top earners have the same deductions as lesser earners. But in the end, it also effectively limits total donations to charity and makes a favored practice of many top earners that much more difficult. Indeed, the amount of money in question, 7 cents for every dollar, adds up to a staggering amount of $467 billion over 10 years, according to White House estimates. If you give to charities of your own selection, then this will be an important development to follow for the sake of your charities of choice and to anticipate your upcoming tax liabilities. This is the Law Office of David Parker. I'm an estate planning and elder law attorney, and you can check out more information at my website, www.parkertrustlaw.com. Estate tax filing for 2010, deadline extended. This is David Parker with the Law Office of David Parker and another entry on my video blog. If you're an executor for someone who died in 2010, mark your calendar for January 17, 2012. That's the new date by which you must now file a key federal tax form. If your last name is Steinbrenner, or you also are heir to the estate of a decedent who passed in 2010, then you likely know that your assets stand at the crossroads, and that the estate executor has a huge choice to file for an estate tax or not to file. That is the question being asked by all New York State planning attorneys. Formally, the deadline was November 15, 2010, only a couple of weeks out. Good news, now the deadline has been extended to January 17, 2012. So why is there even a choice to file an estate tax return anyway, and why might it be a difficult choice? It exists, as you may know, because last December's budget compromise created an estate tax for the year in which there wasn't any estate tax. The move was to offer a retroactive estate tax to cover up the hole Congress had previously left open by allowing the 2010 time to lapse. Of course, practically speaking anyway, it still doesn't sound like a choice was created because, well, who would choose the estate tax? Indeed, there is a reason to choose the estate tax, but it depends entirely on the nature of the assets in the estate because of the carryover basis versus the stepped-up basis dilemma. If you choose not to pay the estate tax, then it catches up to you in the form of capital gains taxes upon the eventual sale of those assets. This is because the IRS will use the carryover basis or the original cost of the asset when determining capital gains. Assets that have a significantly appreciated or assets for which you cannot prove an original value can become liabilities if you also plan to sell them. On the other hand, if you choose to pay the tax, 35% on assets in excess of $5 million, then the IRS will use the stepped-up basis or current market value when determining the capital gains tax owed. More advice and information can be found in Deborah Jacobs' recent article, as well as an earlier New York Times piece, but so much depends on the particular assets and record-keeping abilities of the estate. Bottom line, as with any estate tax planning, make sure you consult with competent legal counsel, especially well before the clock runs out on January 17, 2012. In such instances, it may be prudent to file the estate tax return since you won't pay taxes, but the rest involve a different calculation. This is David Parker with the Law Office of David Parker and another video blog entry. Elder care. Transition travails. Care transitions, those times when someone enters a hospital, transfers from one department to another, gets discharged to a rehabilitation center, or goes home, are risky times. Moving between hospitals or into rehabilitation and other care centers can be a stressful time, especially for elderly loved ones. Unfortunately, too, these care transitions can create far greater problems than stress, as they are prone to creating problems with the patient's care. Potentially, these problems can have long-term effects. Care transitions are not a recent concern of health professionals, but have been on the radar screen for some time. In fact, a recent study is the subject of a recent New York Times article post in their blog series, The New Old Age. According to the study, a very large Canadian study of older adults published in the Journal of American Medical Association found the main problem is with essential medications. It seems these meds can be accidentally stopped by healthcare professionals when the patient is in transition, and older persons can be on many medications at once, often with little understanding of each drug and with complete faith in the multiple doctors prescribing them. For example, what happens if an elderly loved one, who may be on as many as 10 medications, has an episode requiring a trip to the emergency room? The emergency room staff may have to take them off some of those medications to administer needed care. Unfortunately, thereafter, the doctor may forget to have those medications started up again once they are stabilized, moved to regular care, or even transferred out to a rehabilitation center. In turn, your loved one might not notice any changes without the meds, or simply might assume the doctors know what's best. Ultimately, this lack of communication and coordination in transition care can be life-threatening. As a New York estate planning attorney, I find it sometimes happens that all too often, particularly with medications for cardiac and blood conditions such as statins like Lipitor and blood thinners like Plavix. All of this gives family caregivers one more thing to bear in mind when tending to an elderly loved one, but it also can be an important one. It's important to ask questions and be aware of all medications an elderly loved one is taking, and if these meds change or stop after a hospital visit, find out why. Retirement accounts. Distribution rules are complex. As the amount of money stashed in 401ks and individual retirement accounts has grown, more and more families are finding themselves locked in battles over who has rights to the assets. Even with the many concerns over retirement accounts in America, it's undeniable. IRAs and 401ks represent a lot of personal wealth for everyday Americans. That means retirement accounts are assets uniquely worthy of particular attention, to include when it comes to their role in your estate planning. Indeed, amongst households with at least $100,000 to invest, 60% of the household's assets are in an IRA or 401k. So, how ought retirement accounts factor into your estate planning? Who will inherit them? The answer is not as simple as you may think. Truth be told, the problem with retirement accounts is the crazy quilt of laws governing their distributions, and moreover, different laws apply to 401ks and IRAs. The inheritance of retirement accounts is a lively topic, and none other than the Wall Street Journal has recently offered a piece on the issue. While I commend the full article to your reading, let's review a few of the highlights here. With 401ks, the overarching rules are in place thanks to the Federal Employee Retirement Income Security Act, ERISA. If you're married, the 401k automatically passes to your spouse and does so regardless of whether your spouse is designated beneficiary, unless your spouse waives his or her right to your 401k. By the way, if you have a premarital agreement, your intended spouse cannot effectively waive rights in your 401k until you are actually married. Plan accordingly. What if you have children from a former marriage and you want to include them as beneficiaries along with your new spouse? Consider rolling your 401k into an IRA and making the beneficiary designations per your wishes, even if your children are beneficiaries under your will and trust. Teaching point. The beneficiary designations on file with the retirement plan administrator trump any contrary arguments in your will and trust. In fact, the U.S. Supreme Court has ruled that, despite any state law to the contrary, Your ex-spouse will inherit your 401k if he or she is the last designated beneficiary on file with the plan administrator. IRAs are governed by state law, and that, by and large, makes them more pliable. Without the inflexibility of the ERISA laws, when it comes to your IRA, it's all about the named beneficiary, unless there is a state law to the contrary. One thing remains consistent, however. Beneficiary on file with the plan administrator takes precedent over any provisions under your will or trust. Exceptions: some state laws rule out the complete disinheritance of a spouse, and some have laws automatically disinheriting an ex-spouse as beneficiary, unless you've completed the extra paperwork to confirm your intent to include your ex-spouse as beneficiary. I discuss beneficiary designations on my website, especially the video 3 Ways to Avoid Probate Without an Attorney. The video is free, but you must enter your email to view it. Bottom line, if you're concerned about a New York asset protection, then retirement accounts, whether 401ks or IRAs, are important assets for any Americans. Given the complex tangle of laws that control your options, it is essential that you consult with a competent legal counsel and coordinate the distribution of your retirement accounts as part of your overall estate plan. Be sure to consult an estate planning attorney admitted in your state of residence, as state property laws may need to be reevaluated as well. This is David Parker with the Law Office of David Parker, and another entry on my video blog. Joint ownership, hidden pitfalls to avoid. One of the most common estate planning mistakes that people make is joint ownership. Estate planning can be daunting. Once you get past the fact that your very mortality and morbidity is the triggering event, estate planning means taking stock of all you own,